All right, you are all set.
Okay. All right, everybody. Thanks so much for coming. This is exciting. This is a time when I get to geek out with all of my legal knowledge and experience about this portion of what we do, which is really like 20% of what we do at the law firm is employment contract stuff. So we've represented thousands of companies, hundreds of employees too. So we're on every side of this, and we've kind of litigated them. We've done, written the contracts. We've enforced the contracts. We've done everything you can possibly imagine to do with employment contracts. So this is how to write the best ones, and if you're an employee yourself, how to get around the worst. so so here we go. We'll jump right in. There will be a copy of this released to everybody, a recording too. So if you miss out on any of it, you're welcome to hop back in. Okay, so our main agenda today is going to be, the advice to be the drafter. When do I draft an employment contract? When's the best time? What are the best contract revisions to make if you're going to change it? All of our different compensation schemes, job descriptions and handbooks, what to put into those, and of course, employee incentives, profit shares if you're going to do something groovy like that. There will be some time for questions after if anybody's interested. You can just put into the chat, and then Elizabeth will help get those to me. All right, so the first part of the advice is to always be the drafter. This is very important for all contracts. So really any contract that's written, the person that drafts it, the person that hires a lawyer to write it for them, that lawyer is on a legal duty to write it as most favorably as they can for whoever their client is that's hiring them to do it, right? So even if there's two sides that are negotiating the terms of an agreement, the side that did the first draft of it, not the side that's editing it and redlining it, will typically get in a lot better and more provisions that are favorable for their client than the other side, because you can only make some beef about so much before you just kind of look like a jerk, right? So you can only kind of take issue with 4 or 5 provisions in a contract, even if it's like a 20-page contract, before you start to just look silly and people are like, come on here, what's the deal? So it's best to be the person that drafts the initial version of the contract, and of course whoever drafts it is going to be in the most favorable position. Also, employment laws are different from other laws because they kind of stack the deck against the employer. It's unfortunate, but it's really difficult for employers to be in an equal, much less favorable position unless they've drafted their own employment contract. So most of the FLSA laws, the EEOC stuff, all of it, the healthcare laws, even taxes and stuff, can be against the employer. It's very often employee friendly, even in red states, which for the most of its history, Georgia has been a red state, but now it's a purple state or a blue state. Okay, so the only way to make it favorable to the company again is to, of course, write your own one and put your awesome stuff in there. Yes, if your question is if the employees can come back and redline the proposed contract, they often actually do if it's an executive level, C-level employee, but that's actually great for you. So if you present them with a contract that you drafted and the employee hires their own attorney or just edits it themselves, that shows that you had a deal that was struck where both parties had their input, and it gives you a really binding, strong agreement that will be hard to overturn later on, even if you guys have a falling out. Okay, so it's actually best if you give them a contract and they give you some edits that they would like to include. So that's like the best contract and the easiest for us to litigate. Okay, so when is the best time to draft or deliver an employment contract? might be obvious, but the very best time to deliver an employment contract is on their very first day. In fact, before they even start to do a bit of work for you, you want them to sign this thing. That's best. It doesn't always happen that way, of course. That ship has sailed for most companies. So the second best time to give an employee an employment contract is whenever you're going to give them some other compensation that's not their normal salary or hourly compensation. So if you're going to give them a bonus, if you're going to give them a raise, anything like that, that will make it more binding. So it's an agreement, it's a contract that is more enforceable. Why is this important? So we have this thing in contract law called consideration. A consideration is just additional revenue or compensation of some form for an additional service, right? Because you've been paying them for signing off on your prior contract, even if you didn't have one written. So if you want to give them a new contract, it would be better, it would be stronger for us and easier for us as lawyers to litigate it if we had a extra compensation. So my easy example is if I'm getting an oil change, they quote me at like, $30 for, the whatever regular oil, right? But I have a nicer car and I really want them to use synthetic. So, I want them to do that, but in order to do it, I need to pay them the extra cost for synthetic oil and whatever their upcharge is. So that's additional. Similarly, if you're going to give them additional compensation in the form of a bonus or a raise, that is the very best time, except for their first day on the job, to give them that contract to sign. Okay, so let's see, where are we? Okay, so if you don't have one of those times, the third best time is just right now. So you don't want an employee to not have an employment agreement signed when and if they are terminated or if they decide to quit. And it's quite common that you have an employee that is going to be terminated soon, or they're making rumblings that sound like they're going to quit soon. And if that's the case, you really want them to sign something, because if they haven't signed anything, you're kind of out of luck. And we'll go over that here in just a second. So the third best time to have them sign something is just as soon as possible. In most states, I don't know if it's most states, but it's about half, continued employment is sufficient consideration for a new contract. So although it's not as strong as if you offered them some sort of a bonus or a raise, like we talked about before, the fact that you will continue to employ them and pay them for future work is by some states considered enough to get them to sign this new thing. But then we kind of have to fight those battles. So that's kind of putting it all in perspective for you. All right, cool. So this is the fun part. So what are the best contract provisions that we can put into this puppy? Okay, so non-competes, non-disparagement, non-solicitation. These are the top three these days. Non-competes are actually, they're limited in scope normally, okay? So a non-compete limits that employee's ability to compete with your company in a certain industry, which is a scope limit, in a certain geography or territory, which is another scope limit, for a certain amount of time, which is the third scope limit. So you've got the type of competing activities, you've got the geographic area that they're competing in or not, and you have the time that they're not allowed to compete with you. So those three factors are provisions that you put into this non-compete agreement, depending on the state that you're in. If you're in Georgia, you're pretty much okay with a 2-year non-compete after they're fired or if they quit. But in other states, it's different. In California, they pretty much don't allow any non-competes, and they even kind of punish employers for trying to get a non-compete. So don't do non-competes in California. So we can go over the fuzzy stuff about the geographic territory. somebody might say, well, I'm a national company because I have a website, or an international company because people in Britain, have looked at my website before. So technically, I could have some customers in Britain. I would love to restrict my employees' ability to ever do any work in Britain, much less, the United States. And, that's probably not going to pass muster unless you actually have a lot of customers in Britain, right? But the majority of the time, 10-mile radius from the principal place of business is okay. I've seen as much as, the whole Southeast region as being enough if you can prove to the court that you're actually doing work, doing business actively in all of those territories. But anyway, that's the scope of the non-compete. Okay, so different from that is non-disparagements. These are a big deal these days because online reviews are such a thing. Now disgruntled employees have this sounding board where they can say, a negative statement about their prior employer, and hundreds of thousands of people can read it, and your online reputation and credibility is just smashed. So what we like to put in here is requirements that they do not disparage the company for any reason. And certainly if they have disparaged the company, if they left and then wrote some negative reviews, you have some toothy contracts that can kind of claw those back and get them to be taken down, and sue for breach of contract, right? Which is a big deal. I mean, it's pretty easy to prove that your company has been harmed reputation wise, even, or for future employees by an employee's negative reviews. So non-disparagement is a big deal. Okay, so people often confuse non-solicitations with non-competes. I was totally confused about it before law school, and it is confusing. But if you recall, non-competes has those three scopes. So it's limited in time, limited in geography, and limited by the context, by the type of competing activities that are considered to compete, if you will. A non-solicitation is quite different. The non-solicitation is only about soliciting people. So literally, if I pick up my phone and I call somebody, that used to be a customer that I worked with for my prior employer, and I had signed a non-solicitation agreement with them, that's going to be an issue, and they can probably sue me for breach of contract, and whatever the value of that customer was, they can probably claw back and get back from me. But also, it's not just customers; it's also non-soliciting all other employees. So it's common for employees to try to set up their own company, for example, and they might say, Sally over here was a total rock star, and Bob over here was great too. So I'm going to cherry pick their best employees, and I'm going to offer them like a 10% raise, and I'm just going to grab them, and then we're going to set up a competing company. First of all, that would be limited by their non-compete. So if you had an employment contract, they couldn't do that in the first place. But also the non-solicitation thing is, another problem there. So you could have a double breach, right? So if they actually solicited the other employees to leave your company after you've spent all of this money on their training, development, processes, knowledge of your trade, of your business, whatever it is, you don't want them to be able to steal your employees. There's a lot of a company's value in its employees. Okay, the third solicitation that you can't do is vendors. It's really common for distribution companies to have contacts with particular manufacturers, or even if you're a professional services company, you have various marketing vendors and tax prep vendors, and people that just help you to do things better, and you get special deals with them because you've been working with them for a long time. You don't want your ex-employees to be able to grab your vendors and solicit them for a competing company. Okay, so I know that's all just encapsulated in one bullet, but there's a lot of cool stuff that you need to be aware of with restrictive covenants. Okay, so protections of your company's valuable intellectual property. So there's something called a work for hire provision. It has special laws around it, federal laws based on the US Copyright Act, that makes it so that any intellectual property that an employee creates for your company while sort of on the clock for your company is owned by the company, like instantaneously. Okay. If you don't have a work for hire provision, they have a very good argument that they, in fact, own the IP that they've created and the company does not. So, pursuant to the Fifth Amendment of the United States Constitution, whenever you make something creatively, if I draw this stick figure, okay, this is I have the copyright to this stick figure. I own it. It's mine. But if I signed a work for hire provision in an employment contract for my employer, that employer can say that because, Jonathan, you're doing work for Sparks Law right now, this is instantaneously transferred to Sparks Law, and you don't own Jack. This guy's name is Jack. Okay? Makes sense? So you need a work for hire provision in all of your employment contracts, especially if they're developing any kind of intellectual property. Okay? So if you've got a tech company, you've got a software company, even if you've got a company that's just doing some marketing stuff, they need to sign a work for hire provision for copyrighted material, your videos that you've made, logos, anything like that. Okay, so super important. And it's also important if they live in another country. It's really common these days to get developers for software out of India or Pakistan. If they're out there, we still need them to sign this so that you can own the IP wherever you need to own it. Okay, because otherwise they have an argument that they own it. Same thing with your trademarks, patents, trade secrets. If you don't actually own them, if you don't have your trademarks registered, for example, give us a holler, because that's it's a separate thing. But you need the employees to give you rights, title, and interest to be a total lawyer about it for anything that they create. Okay, so the last big provision in the employment contracts that we have is called misclassification issues. This is a factor-based test. It's basically, how are you paying the employee? Are you paying them on a 1099 or are you paying them on a W-2? Okay, so it's a big deal if you quote unquote misclassify them and you don't do tax withholdings. Okay, so if you withhold for taxes and pay payroll taxes and all of this and have them on a W-2, the IRS and the Department of Labor are probably going to be cool with you because they want you to, pay for overtime, make tax withholdings, pay payroll taxes, and all of that. You can get away with paying people on 1099 bases as long as you pass this factor-based test. Some of the factors include, and I'm not going to get into them all because it'll just bore you to tears, but some of the factors include whether or not they're using their own equipment. It includes whether or not they're doing the actual service that you're offering. So if I hire a painter to paint my office, like I did, that's not legal work. So it's probably going to be fine for me to just pay him on a 1099 basis, whatever he charged, rather than on a W-2 and do withholdings, right? But if I'm hiring out a lawyer to communicate with clients and do client work on a regular basis for 30 hours a week or more, I really need to make withholdings for that lawyer. Okay, so if it's crucial to the business that you're giving to people, the products or services that you deliver to your customers, it's probably going to need to be on a W-2. When in doubt, put them on a W-2 if you can afford it. And if you can't afford it, then let's talk. Okay, so potentially, I just got to say, misclassification claims are usually over $70,000 per employee. And because of the laws are written, remember that the deck is stacked against the employer. These are a really big deal. Also, with the way the laws are written, the employer is usually personally liable for misclassification cases. That's a big problem, okay? That means you can't, step away from your company, even if it's a tiny one, right? Like you're personally liable for it. You don't get limited liability for that issue, for that cost. And to make it worse, you have to pay for the other lawyers' fees, which is, can be 50 grand pretty easily. Most lawyers that do this type of stuff on the plaintiff side do it on a contingency basis, and they kind of don't have a limit on what they can charge you for their reasonable legal fees, right? I'm putting this in quotes because it can get ridiculous to me, but it can easily be 50 grand. So be cautious, right? All right, so we're going to move on. So what about compensation? So you need to put in your employment contract exactly what I mean, this is what it's all about, right? Their whole job is to do work that's beneficial to the company, and your whole job is to pay them for doing that, right? So how do you pay them? What are you promising to pay them? What are you not promising to pay them? All of this needs to be specified, what they get and what they do not get. If it's not specified in the contract, generally the judge will agree with the employee's side and they will disagree with the employer. They'll kind of use it against you. So they'll interpret it in the most favorable way possible, because judges just tend to love employees and they don't tend to like employers for whatever reason. Apparently, there's some judges in Delaware that love employers, but I don't know. Okay, so do they get paid time off or not? That's a big question. So if they get PTO, they get paid time off, is that accrued or do they get the whole PTO on January 1st? There's going to be a lot of people this year, like every year, that were working on January 1st, and in their, employee contracts or offer letters or handbooks or whatever, it says everybody gets, 10 or 15 days of PTO each year. But because that's not specified as accrued, that means that they could quit on January 2nd and they could say, hey, you owe me for all 3 weeks of my PTO for 2021, right? Just because they worked one day in that year and then they just sort of got it all. Okay, so you need to specify it, because otherwise, if you don't specify, a judge will probably interpret it against the employer. So I hope that makes sense. If it doesn't make sense, drop a question in the chat and we'll get to it when we wrap up. So also, is their compensation tied to performance metrics? It's so great if you can tie it to a performance metric, because then, if the company's doing great and they're performing really well, everybody makes more money. And similarly, if the company's not doing well and they're not performing well, you don't have to pay them for their sort of botched work, right? But if you're going to do this, if you're going to withhold compensation from them, withhold pay, excuse me, you have to put that into the contract and they have to sign it, because if they don't sign it, no judge is going to agree with you. So if you don't specify the compensation rules, the courts will assume the worst and the best for the employee. So the worst for you, best for the employee. So make sure all of your rules are outlined in the contract. All right, this is quick. We've gotten through most of it. So job descriptions and handbooks. Job descriptions are kind of a hot button issue these days in the world of employment law, because a lot of employees are now saying, and maybe this is, I don't know if this is a generational thing or like a cultural thing that we've got now, but a lot of employees will say, that is not in my job description. So, if you expect your employees to do random administrative tasks, such as going on a coffee run, a little bit of cleaning or a lot of cleaning, picking up the mail or something, or going to the post office, random stuff. If you're going to throw on lunch and learn, for example, do you want them to go get some iced tea and lemonade? I know this doesn't sound like a random idea, but if this ever happens to you, then that employee can and has said many times in the past, that's not in my job description, I ain't doing it. And they're right. I mean, if you want to be technical about it, they're right. So in your job descriptions, if you use any, we always recommend putting this language, and you're welcome to lift this from this presentation. But it includes their basic stuff that you expect them to do. But I'd also say any other administrative tasks requested during normal business hours by the staff. So that way, you can say it's a catch-all. So you could say, yeah, I did expect you to go get that iced tea for our lunch and learn, at 11:30 or whatever. Handbooks importantly protect your company against false claims of discrimination and harassment. These claims are often false. They're not always false. If they're not false, then shame on you. But if they are false, then you need that in your handbook to show that it's important to your company to not discriminate or harass employees, of course, and that any alleged harassment that took place was not sanctioned by the business owners or the boss or supervisors or whoever. Okay, so it's very important to have a handbook that goes over discriminatory and harassment material. Okay, so last but not least, a lot of these groovy contracts want to give their employees incentives like profit shares, actual equity in the company, stock options, that sort of thing. You can absolutely do this, but it makes it 10 times more complicated because there's a lot more employment laws that apply to giving them a profit share or ownership in your company, with a vesting schedule and things like that. I'd say the most common problem that employers run into with this whole gig that they're a startup, maybe they're a cool tech startup, and they're giving them an independent contractor agreement, like we talked about earlier. You remember the discussion about independent contractors versus like 1099s versus W-2s. If you're paying them on an independent contractor basis, then that's an issue, especially if you're giving them these stock options and things. So there's kind of a tension there. It's not normal that I would pay a painter equity in my firm for his job painting for my firm. You're right. So that unless he's a W-2 employee. So, all right. So that being said, if you're going to offer any of this, you have to update all of your organizational documents. What does that mean? That's your corporate binder. If you have an LLC, it's your operating agreement, it's your partnership agreements, it's your bylaws, your shareholder agreements, your meeting minutes, all of this stuff, because I'll be damned if my employment contract butts heads with my organizational documents. Okay, so and if that happens, a judge gets to basically write your partnership agreement. They get to write your organizational documents, your bylaws, your shareholder agreement, your corporate binder, and you don't want a judge to write that for you. You want to write it yourself. So if you're going to offer an employee special incentive plans like this, you got to revise your organizational documents. I hope that makes sense. It's pretty complicated stuff, but basically these contracts need to all feather together. They need to dovetail together and work in tandem. If they don't work in tandem, it's on you, right? So you're going to be punished for it. I will say that there's another type of incentive-based stock program that's not actual stock. It's called phantom stock. Happy to talk about that. It's a pretty cool new groovy, legal technology, but probably outside the scope of our presentation today. So that's it. That's all we got. So that's that's a solid half hour. I anticipate that there's going to be some questions, and I'll give you guys a bit to see if there are. You're welcome to put them into the chat, or you can go ahead and unmute yourself if you just wanted to ask some. And then if you came up with questions later, feel free to just reach out to us on my email is here, jsparks@sparkslawpractice.com, or you can call us at 470-268-5234. So EJ, did we have any questions?
We don't have any questions in the chat. Does anybody have any that they would like to ask before we end our Smart Sparks?
Doesn't sound like it. Okay, awesome. I'm glad that all made sense to you guys. Seems like I'm like a rock star presenter here because that was some pretty complicated stuff. But you guys are all professionals and you're on the up and up. So if you ever have questions, feel free to reach out and keep rocking, guys. We love having you. Thanks for attending Smart Sparks.